governmental interest test and the least restrictive means test goes far beyond any simple accommodation. For example, an accommodation might be something like a burden shifting provision, forcing zoning boards to have the burden of persuasion. But RLUIPA goes far beyond that and forces the zoning boards to justify their decisions under the most demanding standard known to constitutional law. Consider how a zoning board could possibly meet this standard with interests such as traffic. A zoning board is simply never going to be able to meet the compelling governmental interest standard, which highlights how this is not simply a protection of religion, but it goes far beyond that and into the area of an actual benefit granted to religion. The petitioners would not be here if they were not a religious organization. All secular private schools or secular organizations are not privileged to the same benefits, and so Congress has clearly evidenced a preference for religion over non-religion, which this court states violates the Establishment Clause. Because RLUIPA violates Section 5 and the Establishment Clause of the Constitution, those are two independent reasons for striking down RLUIPA and affirming the judgment of the 14th Circuit. Thank you.
Thank you.
Mr. Chief Justice, and may it please the Court, my name is Allison Ryman, and I will be addressing the Individuals with Disabilities Education Act issue for respondent. Your Honors, this case asks whether the parent of a disabled child who disagrees with the proposed public special education placement can simply bypass that proposed placement and without ever giving it a chance to succeed, instead seek from the courts a private education for his child at public expense. I will argue tonight that the answer clearly is no. The IDEA's text contains a threshold condition that a disabled child must first receive public special education services.
Are you arguing that this court should mandate a child to enroll in a public school where the parent believes the IEP is inadequate until it becomes clear that the placement is inadequate? Or is that what you're arguing?
Your Honor, we are simply arguing that the plain language of 20 U.S.C. Section 1412 A10C2 does in fact require a child to previously receive public special education services before his parent may be eligible for tuition.
What if it's patently inadequate? What if it just couldn't be clearer that the IEP just is not good? The parent still has to go into to subject, isn't it a Hobson's choice for the parent to say, well, I know, let's say any reasonable person in this room would know that it's inadequate. You still have to subject your child to that under the idea?
Your Honor, to be eligible for tuition reimbursement under subsection 2, that would be correct.
For how long? How long do you have to?
Your Honor, to previously receive public special education services, by the plain meaning of those terms, a child would have previously received those services after 1 day. But that doesn't mean necessarily that a parent could remove his child from that program after one single day.
So how long? How long?
Your Honor, appropriately, Congress left unspecified the exact amount of time.
So then what's wrong with 1 day?
What you're saying is if George, in this case, spent 1 week in a school, then he'd be eligible for reimbursement if the parents decided to yank the kid out after a week's time. Isn't that arbitrary?
No, Your Honor. Your Honor, it would be necessary to look at the conditions specified in subsection 3, which limit the availability of tuition reimbursement that is provided in subsection 2. Subsection 3 requires, first of all, that parents notify the IEP team at the most recent IEP meeting, as well as notify the school that they are withdrawing their child within 10 business days. But in addition to these notice requirements, a parent must act reasonably. And one factor that
should a parent be required to undertake a futile act that clearly it's obvious that the IEP is no good? What could be the legislative purpose to make the parent go through this charade? Something that clearly that child is going to have to go into something, another program that will provide adequate educational services to the child.
Your Honor, the reason for a tryout period would be to give both the schools and the parents a chance to see the IEP placement at work with hard facts before a final decision is made.
But it's clear in its face that it's inadequate. We've told the school, as the parent, I've told the school that this cannot be adequate. You still have to go through it according to the language of the statute. You still have to go into that public school and go through what may be, again, the futile acts. Your argument is that, yes, you have to do that. Is that what you say?
Let me just add a footnote to Justice Lippman's hypothetical. My child is autistic. Every doctor I've taken my child to says he's autistic. I go to the school district. The principal says, look, we're just out of money. We just don't have the resources. But what we can do is we have an autistic counselor. And your autistic kid can meet with the autistic counselor Monday, Wednesday, and Friday at lunchtime for 15 minutes. That's the IEP. Do I have to go through that before I can send my kid to Kildonian or wherever it is and seek reimbursement?
Your Honor, the balance that Congress has struck between the rights of parents and the rights of schools has come out on the side of putting public schools first.
So is your answer to the question yes?
Yes, Your Honor. You would have to place your child in that program.
Really?
Yes, Your Honor, because
Wow.
Why does it have to be, and does it have to be that program? I have a slightly different question.
Go ahead.
If my child is 15 and autistic, and when he was 4, he received speech pathology pursuant to an IEP in some other county. Now he's 15, he's autistic, he's in the same situation Chief Justice Parker just described. I've satisfied this, right? Because it says, receive special education and related services under the authority of a public agency. So I'm okay then, right?
Your Honor, if you could satisfy subsection 3, then you would be covered.
I would be okay then,
Well,
even though it was the services were speech pathology 11 years ago?
Your Honor, most likely you would not be able to satisfy subsection 3.
But I
Because
would satisfy this section right here.
Your Honor, that's correct, but
Does
subsection...
that make sense to you?
Your Honor, it does, because subsection 3 modifies subsection 2. It places limitations on the availability of tuition reimbursement under subsection 2. You see, for you to be eligible for your child for tuition reimbursement, you would have had to have notified that child's IEP team at the most recent IEP meeting that you had concerns about the program and were going to withdraw that child.
What should we do about the fact that 3 circuit courts that have ruled on this have all said we should look at 1415, which gives us the equitable power to do this, and that we shouldn't read that out of the statute either? So why can't we turn to that and say there's no reason to go through this useless, frivolous task of putting the kid in school if the program is no good? We should reimburse.
Well, Your Honor, the reason that Section 1415 does not apply here is that Section 1412 A10C2 places clear limitations on the availability of the tuition reimbursement remedy under Section 1415. You see, when Congress amended the statute in 1997, it is evident that Congress fully intended to address the responsibilities for the costs of private school tuition